In the matter of LifeCare Innovations Private Limited versus Union of India, Supreme Court directed the authorities, including the review committee and in particular the Grievance Cell, which is specifically entrusted with the obligation to redress imposition of unreasonable conditions in tenders floated by government departments or agencies that put micro and small enterprises at a disadvantage, to examine limits of minimum turnover clauses and issue necessary and appropriate policy guidelines. It is also directed that the Public Procurement Policy for Micro and Small Enterprises Order 2012 has a force of law as it is formulated in exercise of power under Section 11 of the Act and also encapsulates the purpose and object of the Act. Though there is no mandatory minimum procurement right for an individual MSC, there is certainly a statutorily recognized obligation on the authorities and the bodies under the Act and the Procurement Order 2012 to implement the mandate, which is subject to judicial review. The judicial review will primarily ensure proper constitution and effective functioning of the authorities, the National Board of MSMEs, the Advisory Committee, the Facilitation Council, the Review Committee, and the Grievance Cells, and leave the policy and decision making to them. The respondents, in particular the Review Committee, constituted under Clause 12 of the Procurement Preference Policy 2012 to examine the issue of mandatory procurement of 25% of the goods and services by the government and its instrumentalities from MSEs under Clause 3 of the policy in the context of Clause 11, providing for reservation of specific items for procurement and take such action as is necessary for effective implementation of the policy within a period of 60 days from order. And the respondents, including the review committee, and in particular the grievance cell, shall examine the declared limits of minimum turnover clauses with respect to MSEs and issue appropriate policy guidelines within a period of 60 days from this order. Supreme Court also stated that the purpose and object of entertaining this writ petition under Article 32 of the Constitution is not so much to inquire into the individual grievance of the petitioner than to examine the nature of the rights created by the procurement order 2012 and the remedies available to the stakeholders and to declare with clarity, certainty, the scope of judicial review for effective implementation of the policy. The grievance cell is specifically mandated to take up issues related to the imposition of unreasonable conditions in tenders floated by the government departments or agencies that put MSEs at a disadvantage. This will certainly include the prescription of minimum turnover clauses. The functioning of grievance cell has come under the scrutiny of Comptroller and Auditor General of India, which has suggested improvement in the functioning of this body. Court said that the significance of creation and establishment of these statutory and administrative bodies is not difficult to conceive. If these institutions and bodies work effectively and efficiently, it is but natural that the purpose and object of the legislation will be achieved in a substantial measure. Therefore, it is necessary to ensure that in the functioning of these bodies there is efficiency in administration, expertise through composition, and integrity through human resources, transparency and accountability, and responsibility through regular review, audits, and assessments. While exercising judicial review of administrative action in context of statutes, laws, rules, or policies establishing statutory or administrative bodies to implement the provisions of the act or its policy, the first duty of constitutional courts is to ensure that these bodies are in a position to effectively and efficiently perform their obligations. This approach towards judicial review has multiple advantages. In the first place, while continually operating in this field with domain experts, these bodies acquire domain expertise, the consequence of which would also be informed decision making and consistency. Further, critical mass of institutional memory acquired by these bodies will have a direct bearing on systematic development of the sector, and it will also help in handling polycentric issues. Thirdly, while continuously being on the field and having acquired the capability of making real time assessments about the working of the policies, these bodies will be in a position to visualize correct course correction for future policy making. Shifting the focus of judicial review to function capability of these bodies is not to be understood as an argument for alternative remedy, much less as a suggestion for judicial restraint. In fact, This shift is in recognition of an important feature of judicial review, which performs the vital role of institutionalizing authorities and bodies impressed with the statutory duties, ensuring they function effectively and efficiently. The power of judicial review in matters concerning implementation of policy objectives should transcend the standard power of judicial review to issue writs to perform statutory duty and proceed to examine whether the duty bearers, the authorities, the bodies constituted properly, and also whether they are functioning effectively and efficiently. By ensuring institutional integrity, we achieve our institutional objectives. Further, effective and efficient performance of the institutes can reduce unnecessary litigation.